Before we get into this, I just want to say I'm not a lawyer. I'm not a lawyer in Australia. I'm not a lawyer in Japan. I'm not a lawyer anywhere. I'm just a bunny who can read. If any legal professionals want to critique what I say in this video with their actual lawyer opinions, I would totally welcome that. In fact, I would love to hear what the professional lawyers have to say about this. None of what I say in this video is legal advice because, as I just said, I'm not a lawyer. And as always, please don't send any harassment anyone's way on behalf of me or anybody else. If you really love the talents, you will support them, irregardless of whatever crappy situation they may or may not find themselves to be in. With all that out of the way, let's get into it. So as we're all aware, the other day, the Nijisanji contracts got leaked. An unsigned version of the Nijisanji talent contract was released, and a actual lawyer, shouts out legal mindset, sat down for many hours on a live stream and just tore this contract apart, ripped it to shreds, and pretty much said, in America, this contract would be non-enforceable. If you were signed into this contract, you would be considered an employee because of all of the legal controls that it places upon you as a talent. And while I should have, been working and doing my 9-to-5 job, I got to thinking, hey, is this even legal in Japan? Because from the outside, I think all of us have a really maybe warped view of Japanese working culture. From what we understand, oh yeah, like working in Japan sucks. You have to do stupid amounts of overtime. You only get 1 day off a week, yada, yada, yada. And I was like, yeah, but just because that's the working culture doesn't mean that's the law. And just because people haven't, say, gone to fight for their rights in court doesn't mean that it makes any of this okay, right? So I was like, well, what the hell are Japanese labor laws anyway? What does any of it say about this type of shit? So I got to researching and I found some really interesting stuff. And you might say to me, hey Meera, why do you give a fuck about this shit? You're not a Nijisanji, you're just a random Vtuber. And to that I would say, hey, they put me on a shit list, so I figured I better do something worthy of being on that list. Let's start this off by reviewing some Japanese labor laws. So this website, Japanese Law Translation, is, as it says in the top corner here, a website operated by the Ministry of Justice that provides translations of Japanese laws and regulations. They do have this notice on their front page, which does indeed state that the translations contained in the Japanese Law Translation Database System are not official text, and not all of the translations are finalized versions. Only the original Japanese text of the laws and regulations have legal effect, and the translations are to be used as reference materials. So basically what they're saying is the translation is not the actual law. You should refer to the actual Japanese text and probably consult, a Japanese lawyer to understand these, but I feel like as Westerners and as somebody who is not fluent in Japanese, this is a great starting point to understand what are Japanese labor laws. Alright, so what we are looking at here is the Japanese Labor Standards Act. As far as I understand, this goes over what the rights of a worker are, what working conditions must be provided by an employer, talks about equal treatment. So in Australia, this would be the equivalent of the Fair Work Act. This covers all of our rights as an employee and what our employer is responsible for. So let's have a review of what it says. I'm going to highlight some key parts that I think are going to be important going forward. We're not going to cover the whole act because, look, this is a long freaking document and a lot of it is irrelevant to what we're talking about. So I'm just going to point out things that I think stand out to me. First thing I kind of want to point out, Article 5, Prohibition of Forced Labor. An employer must not force a worker to work against their will through the use of physical violence, intimidation, confinement, or any other means that unjustly restrict that worker's mental or physical freedom. The next article I want to point out, Article 9. The term worker, as used in this act, means a person who is employed by a business or office, hereinafter referred to as business, and whom wages are paid regardless of the type of occupation. Article 10. In this act, the employer is the person in control of the business, the person responsible for managing the business, or any other person acting on behalf of the person in control of the business in matters concerning that business's workers. Article 11. In this act, wage means wages, salary, allowances, bonuses, and anything else that the employer pays to the worker as remuneration. I can never say this word. Remuneration for labor, regardless of what it is called. Another thing to remember, guys. I think one really important thing to point out here, Article 13. Any part of a labor contract that prescribes working conditions not meeting the standards of this act is void. In such case, the part of the contract that is void is governed by the standards prescribed in this act. Article 15. When entering into a labor contract, the employer must make wages, working hours, and other working conditions explicit to the worker. In doing so, the employer must make explicit the particulars of wages and working hours and any other such particulars that the order of the Ministry of Health, Labor and Welfare prescribes in the manner prescribed by the order of the Ministry of Health, Labor and Welfare. So basically they're just saying when you sign a labor contract, your employer must tell you what your wages are, what your working hours are, and what the other conditions of your employment are. Article 16, you guys are probably going to jump up at this one. An employer must not form a contract that prescribes a monetary penalty for breach of labor contract or establishes the amount of compensation for loss or for damage in advance. Article 19, this section is regarding dismissal of workers. Advanced notice of dismissal. Article 20, if an employer wishes to dismiss a worker, the employer must provide at least 30 days advance notice. An employer not giving the 30 days notice must pay the worker the average wage they would earn in the working period of 30 days. And the second piece of legislation we're going to look at is the Labor Contracts Act. And as we can see from Article 1, the purpose of this act is to contribute to achieving stability in individual labor relationships while protecting workers by ensuring that reasonable working conditions are decided on and reasonable changes to working conditions are made smoothly by providing for the principle of agreement under which a labor contract is to be established or changed by agreement through voluntary negotiation between a worker and an employer and other basic matters concerning labor contracts. Article 11, procedures for changing the rules of employment are governed by the provisions of Article 89 and 90 in the Labor Standards Act. Well, what does that say? Article 89 talks about how an employer that continuously employs 10 or more workers must draw up rules of employment covering the following particulars and must file those rules of employment with the relevant government agency. So this goes into when you have to be at work, how do you pay wages, how do you get, separate from employment, rules of dismissal, blah, 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 blah. Article 90 says, in drawing up or changing the rules of employment, the employer must ask the opinion of the labor union that has been organized by the majority of the workers at that workplace, if there is one, or of a person representing the majority of the workers at the workplace if there is no such union. So now we've had our review of Japanese labor laws. Let's see how this applies to Nijisanji contracts. Now, from what I understand, in Japan, there isn't a lot of difference between somebody who works full-time versus somebody who is an independent contractor. It seems that in a lot of cases, you could be deemed a worker in both of those cases and therefore have the same rights as what we just saw in the Labor Standards Act and the Labor Contracts Act. This is a law firm from Japan, and they have a great page on their website about are you an employee or an independent contractor on here. We have frequently asked by clients whether entering into an independent contractor agreement or Gyomu Itaku Keiyaku, sorry about my shit pronunciation, means they are not entitled to any protections or benefits under Japanese labor laws as they are not a worker, Rodosha, as that term is defined under the law, but it is not always the case as they say. If it is determined that the agreement was actually an employment contract, you may be entitled to protections and benefits under Japanese labor laws. So, what the heck does that mean? Well, let's keep reading. An employment contract involves a worker being engaged by an employer to carry out work in exchange for remuneration paid by the employer. They also tell us what's an independent contractor agreement. They say that this agreement cannot be strictly defined under Japanese law and it's a wide scope. So it's not like in Australia where we have contractors and casual works that are clearly defined in our laws. It's all kind of a little bit wishy-washy and you could be a worker or you may not be a worker. It depends on what you are doing. The key differences between employment contracts and independent contractor agreements. Unlike in employment contracts, independent contractor agreements do not entail superior, subordinate relationships and are not entered into between workers and employers, but rather between two independent businesses. So this is how I feel like a lot of the idol agencies in Japan in general get around treating all of their talent like crap. Just because the document you signed is entitled Independent Contractor Agreement, that does not mean you are not entitled to the various protections and rights afforded to workers. Whether you're a worker under an employment contract or a sole proprietor under an independent contract agreement does not depend on the formalities of how the contract is drafted, but rather on whether key elements of an employment relationship exist between parties. Factors that may indicate the existence of an employment relationship. There is no freedom to accept or reject work requests, nor the instructions for how such work is to be completed. There is significant supervision and control over the work to be completed. There are restrictions on the place of work and hours to be worked. Remuneration is paid. The level of remuneration paid is the same of regular employees. Priority or exclusivity of the role above work, such as stating you will only complete work for this company. Internal work rules and policies and other documents that prescribe workplace conduct are provided. They withhold tax, and you are eligible for severance pay. So these are things that may indicate. That does not mean that they all have to be there to say that you're a worker. I have another source for this. This is from Rippling, which is a global HR, IT, finance, training website. They have a blog post about this where they tell us employee versus contractor, how to classify workers in Japan. An independent contractor in Japan is any person or entity that provides services free of supervision from the client, also known as a freelancer or outsourced work and independent contractor. They have the freedom to accept or regress projects, determine how and when a project gets completed, acquire the funds necessary to complete the project, assume responsibility for their performance, and report earnings as a business income, not salary. A contractor is supposed to have all of this, right? We'll find out if the Nijisanji talents get to have all of this or not. How to hire and pay an independent contractor in Japan. They tell us what are the risks of misclassifying a Japanese independent contractors as employees. An individual's employment status is decided not by their job title or contractual obligations, but in their working conditions. So I feel like, guys, we have a lot of sources saying the same thing, but again, we'll go over it. Are they under someone's control? Are they obliged to follow specific instructions? Do they have the right to refuse assignments or project? Do they have a fixed place and time for work? Are they receiving wages? I feel like we all understand. So, with that all being said, let's have a look at the Nijisanji contract and why I think it's actually still illegal in Japan. Alright, so this is the Nijisanji contract that I have available. The full version of this document is not available anywhere that I've seen, but these are screenshots from Legal Mindset's video when he was showing up the articles in the contract. So I'm just going to point out the parts where, like, explicitly it already contradicts things that we have just looked at, okay? Article 2 of the Nijisanji contract states, during the term of this agreement, Party B shall, as the exclusive Vtuber of Party A is Niji, Party B is the Vtuber, perform duties set forth in Article 3, Paragraph 1, referred to as Vtuber activities for Party A or a third party designated by Party A in accordance with the instruction of Party A, and shall not perform these activities for a third party without prior approval of Party A. I don't know, guys, but that sounds like, to me, exclusive services. Are they under someone else's control? Are they obliged to follow specific instructions of their work? Yes. Article 3 says the content of the Vtuber activities shall follow. So they are laying down what their tasks will be as a Vtuber. Again, that means they don't have the right to refuse assignments or projects. They are obliged to follow specific instructions regarding their work. Sounded like a worker to me. Article 4, consideration. The consideration for Vtuber activities shall be as follows. 50% of the amount paid to and actually received by Party A with respect to the distribution of contents. That sounds like a wage or some other kind of remuneration to me. They also have exclusive fee. In the event that Party A determines it's necessary for Party B to purchase new equipment, they will give you up to 200,000 yen. Okay, that's another form of payment. Performers royalty. Another form of payment. So, but it doesn't say how much here, but it says separate discussion. Same thing for performance performance fee for live concerts, for fees for movies, TV, radio, commercial appearances, merchandising. All of this is a form of wage or other type of remuneration. They also stipulate how they will pay you. Article 6, subcontracting. Party B shall not subcontract all or part of the VTuber activities to a third party or jointly with a third party, except with the prior written consent of Party A. Article 8, obligation to cooperate when requested by Party A. Party B shall participate in meetings, conferences that Party A deems necessary for the execution of VTuber activities. Again, these are more stipulations of what your responsibilities are going to be when you are a talent working for this agency. This is not giving you the freedom as a freelancer to pick and choose your projects and when you want to work and when you don't want to work. They are telling you, you have to come to these meetings and conferences when we say that you do. That is supervision. Article 9, conducting training. Party B shall participate in a VTuber training program upon request of Party A. That comes back to the labor standards law where they are in, what is this? Article 89. This is about drawing up the rules of employment. Part of that is vocational provisions, vocational training, sounding more like you are being treated like a worker than a freelancer to me. However, Nijisanji also wants to treat you like a freelancer in this project, as they stipulate in Article 10, Party B shall procure materials under its own cost and responsibility. That is something a freelancer would do, not a worker. So, you know, they want to, you know, have their cake and eat it too with this. Article 11, management of the information of the account. In the event that Party A creates the account, Party A may provide Party B with the user ID password of the account. So they want to control your social media as well. That's not something a freelancer would do. They would have more freedom. A freelancer would control their own social media because a freelancer is considered to be their own separate business. Article 12, ownership of rights. Party A and B hereby mutually confirm that ownership, intellectual property rights, or any other rights shall belong to Party A or a third party who has granted Party A a license to use, which means you don't own your VTuber, you don't own any of the IP that you create in the course of your work here. When you are a worker working for a company, I know this from the tech industry, they have clauses like this in your employment contract as well, meaning if you develop something for that company that you work for, the IP is not yours. They own that piece of software that you made. This is the same thing for your VTuber avatar and any lore that you might make, any artwork that you might make, even though they are trying to say that you're a freelancer, but a freelancer would get to keep this as their own IP because a freelancer would be their own business. But you are not. They are treating you like a worker in this consideration. Article 13, revenue. Party A shall have the exclusive right to demand and receive from third parties any and all consideration arising from VTuber activities of the second party. They are saying they are able to exclusively demand any compensation you may receive for acting as your VTuber and doing performances and what have you exclusively. Again, coming back to the exclusive services page, okay? They exclusively take your shit. They also stipulate prohibited actions. They tell you all the stuff that you can and can't do. This is stuff that you would find in an employment contract. Article 16, suspending the VTuber activities. In the event that Party B falls under any of the following items, Party A may suspend Party B's participation in the program without needing prior notice from Party A. That directly contradicts what we saw in the Labor Standards Act. Notice must be provided. Article 17, penalty. In the event that Party B falls on the following items, Party A may demand from Party B for penalty equivalent to the 50% of the amount of the consideration, which means if you did something they didn't want you to do and you made money from that, they will take 50% of whatever it is that you made. This is illegal according to the Labor Standards Act, so you cannot put a penalty in your worker contract. Again, Article 20, they say termination. In the event that any of the following events arise with respect to Party B, then without needing any kind of notice from Party A whatsoever, Party A may terminate this agreement. Again, that's in breach. You have to give 30 days. We already saw that. Article 23, amendments to this agreement. In the event that Party A amends this agreement, Party A shall notify Party B in writing of the details of the amendment. In the event that Party B does not object to any amendments in the terms of this agreement within 14 days, Party B shall be deemed to have agreed. So they're saying you have 14 days to agree. If you don't say anything, we assume that you agree. That is wrong. We already saw in the Japanese Labor Act that if they are going to change your employment contract, they need to contact the union person at the place you're employed at or the person who is going to represent you. They can't just say that you agreed. I think we've seen, you know, a bunch of ways that this contract violates even the Labor Standards Act and the Labor Contracts Act in Japan. It's looking all pretty illegal to me. It seems like with the idol industry, a lot of them get stuck in these contracts merely because they cannot afford representation and to fight for themselves in court. However, just recently there was a case where, this is from the Asahi Shimbun, where a former idol worker did sue his former agency and was deemed to be a worker and therefore not liable to pay a penalty for leaving the group. Tenzo Shinazawa was a member of Breakthrough. He quit the idol group and a Osaka district court ruled that he is not liable to pay the penalty because he was a worker who was obligated to follow the instructions from his management agency. Bro, I don't know, that sounded pretty familiar to me, guys. It sounded almost like, you know, exactly what is in the Nijisanji contract. The Osaka-based company, so that would be the agency. They're not going to say their name because of defamation laws in Japan, but they say the agency filed a lawsuit against Shinazawa demanding of 10 million yen, which is apparently 74 grand USDs in penalties for pulling out of Breakthrough without permission. They said that Shinazawa was a business operator who had the freedom to choose his work. This is what I was saying earlier with the are you a freelancer, are you an employee thing. And last year, April 21, Judge Hasegawa rejected the claim and recognized him as a worker defined under the labor standards law based on the group's activities. The court also ordered the company to pay 110,000 yen to Shinazawa in unpaid wages! Like literally exactly what I was saying. According to the ruling and other information, Shinazawa signed an exclusive management contract with the agency in 2019. We just saw that the Nijisanji contract is exclusive. They tell you are not allowed to subcontract out to another agency. He notified the company he was canceling in 2020. So this guy told them in 2020 he wanted to leave, and for 3 fucking years he had to fight in court so that they wouldn't like bill his ass for just wanting to leave. He was recognized as a worker. He was receiving a fixed compensation of 60,000 yen to 160,000 yen a month. So it doesn't even have to say that he was receiving the same amount of money every month. The thing that really seems to be the important part of this case is the fact that it was an exclusive contract. The fact that he was being paid for it meant that he was recognized as a worker. It doesn't matter what he signed. So this could be the case for Nijisanji contracts as well, in my opinion. Again, not a fucking lawyer. Another case that I looked up, this is from Nippon.com. So an article about idols who can't quit. They interviewed a Japanese lawyer who represented an idol group. The lawyer was attorney Kasai Kunitaka. He represented 4 members of the idol group Nijiro Fanfare in a suit against their former agency in 2017. Their case settled satisfactorily for the group after they sought cancellation of their contract, payment of unpaid wages, and other things. I couldn't find the particulars about this case. I tried to look it up, but I couldn't find it. If anybody knows more about this case, I would love to know. Chuck it in the comments. So this is all looking like to me that, like I said earlier, Nijisanji wants to have its cake and eat it too. They want to treat you like a freelancer because it means you don't have access to certain rights and conditions under Japanese labor law, but they also want to treat you like a worker in a lot of respects. They want to control the work that you do. They want to control all your appearances. They control how much money you make. They literally say you may not make any money. They want your exclusive services drafted to them. You can't go work for anyone else. These are all things that a worker would do, but they want to treat you that way, but not give you any of the benefits of that type of relationship, i.e. having secured employment, having a fixed wage, being entitled to time off. I think it comes back to the clip of Sayu on her stream where she was saying, yeah, I talked to a lawyer and I knew that I could win, but they have more money than me and eventually they'll just wait me out and I will not be able to pay for my own representation anymore, and that is how they will get away with it, which fucking sucks because none of this is ever going to change because idols and the entertainment industry is not really a protected thing in Japan from the looks of things, and so a lot of these companies, not just Vtuber agencies, all types of entertainment agencies seem to have these really broad-reaching contracts that violate your rights as a worker. They try to treat you not like a worker, but you are by the definition of the Labor Act, but they say that you're not. They try to say that you're a third-party contractor and they treat you like dirt. I do hope that one of these talents affected by this, if they have in a bad way, that one of them does stick it to them. I hope that one of them does take them to court. I hope fucking somebody sues them and they have to pay a giant fine at the end of the day. You know what I mean? But anyway, guys, that's about it. I hope you enjoyed diving into this rabbit hole with me. I literally spent like way too long researching this to make this video, so I hope you enjoyed it. This is not the type of shit that I usually make. Usually I'm just playing video games and having a good time. If you want to hang out with me when I do that, come to Twitch. We play video games there all the time. Right now we're really loving Helldivers, so yeah, come check us out and I'll see you on the next video. Hopefully we won't be looking at freaking Japanese law again.